Welcome to your state law review session. This is going to be relevant for any of you studying for the 63, the 65, or the 66, because all of those exams test on the Uniform Securities Act and the NASA model rules and policies on the practices and the conduct that they require for securities professionals. Now, we are going to be focusing on Unit 1, which is dealing with the regulation of broker-dealers and agents. That is a little more heavily tested on 63 as compared to 65, 66, but it is relevant for all test takers. We're going to be doing 10 questions together. If you have not had a chance to download and print those questions, I invite you to do so. They're available in your supplements. The way to make the most out of this session is to do each question, pick an answer, identify why you think it's right, and why are those wrong answers wrong before you hear me break it down. That way, you're going to be able to ensure to get the right answer right for the right reason. Where was there a gap in my knowledge? What piece or word or term did I miss? And all of those working together are going to let you get the most value out of the time we spend together. With that, let's jump in to question number 1. If you haven't done it yet, pause that video, do this question. For real, do it. And then I'll be here. I'll be right here ready for you. All right, so I hope you had a chance to answer this question. This is a question about Jules, a recent graduate with a degree in finance. She's looking forward to opening a brokerage account to begin trading. Jules is concerned that her trading activity is going to trigger registration requirements. Will Jules need to register as a broker-dealer as a result of the activity described here in the question stem? What do we think here, gang? I hope that where you landed was no, choice C. Because Jules is not in the business of affecting securities transactions, she is exempt from registration as a broker-dealer. What is a broker-dealer? What's the definition of a broker-dealer? A broker-dealer is a person, remember, broadly defined. So that could be an individual like Jules. More likely in practice, that's a corporation or some sort of business entity that affects transactions for its own account or the account of others. So here we have Jules, who admittedly is going to be affecting transactions for her own account. So why is she not going to have to register as a broker-dealer? Because she's not, quote, in the business of affecting securities transactions. Put differently, there is an exemption for personal brokerage. If you're doing personal trading, that's not going to rise to the level of requiring registration as a broker-dealer. Now, some of you may be jammed up and thinking, well, Dave, how possibly would this individual person, Jules, register as a broker-dealer? Like, what does that even mean? How is that a thing? And you want to remember that on these state law exams, they get real precise. The language in the law is a person who affects securities transactions. So that means it could be a natural person like Jules, like you, or like me, or it could be a corporation. And we don't want to bring that real world. Well, almost all broker-dealers are business entities. They're corporations or partnerships or other structures like that. We don't have individual people who are broker-dealers very often. But on the exam, you just want to show them, hey, I know the rules. I know those rules. All right. What other choices were kind of interesting? Well, I think A is interesting because for the exam, that's not correct. A natural person could apply to register as a broker-dealer under those laws. B, yes, because Jules is affecting securities transactions for the account of others. Well, there's nothing in the question really about the account of others. She's going to be trading for her own account. If she was affecting transactions for the account of others, if she was asking friends, colleagues, other people, hey, can I place trades on your behalf? Now you're getting a little bit closer to that maybe I have to register situation. And D, because Jules is regularly affecting securities transactions for her own account, that's close. And so that's the opportunity for you to say, well, C is that personal brokerage, not in the business exception that you wanted to deliver. All right, let's jump on to question number 2. If you haven't done it, pause now. But you've all done it. So question 2 asks us about individuals representing broker-dealers in the sales of securities must be registered in any state in which they are defined as an agent. There are several exclusions from the definition, including the vacation and the new resident exclusions. To take advantage of these exclusions and avoid registration in a state, all the following requirements must be satisfied except. This is a classic Series 63, 65, 66 state law NASA kind of question. It is long. It is confusing. They threw in some big words like exclusion and exception, and it is tough to unpack, and it's a inversion question, right? It's saying all the following must be satisfied except. So we're looking for what is not required. We want to know what is not required to avail yourself, to use the vacation or new resident exclusions and avoid registration. So what's not required? What do you not have to do? Well, I hope that you found choice A as something that maybe you never really heard about. Pay a fee to the state based on the volume of transactions completed with vacationing or new residents. That's something that we haven't really heard about. And normally I say, listen, never pick an answer on something you don't know about. But what's the exception to that rule? If the question's asking for an exception, the question's asked for something that's not true. So if you are an agent and you're operating outside your registered states because you have a client who's on vacation in that state or just moved to that state, you're going to want to say to that state securities administrator, let me use some examples here. So let's say I'm registered in the state of New York, but one of my clients just moved to Florida, or one of my clients is vacationing in Florida. What do I want to tell the Florida State Securities Administrator as to why I'm doing business in Florida but not registering myself as an agent there? Well, I'm going to tell that State Securities Administrator that B, I'm registered in another state and with FINRA. I'm registered up in New York and I'm registered with FINRA at the national level. I'm going to tell Florida State Securities Administrator, hey, I am eligible to register in Florida if I so choose. I'm not statutorily disqualified. I haven't applied for registration in Florida and been denied. I could register in Florida if I wanted to. And what else would I tell Florida? I would tell Florida, hey, my broker dealer is actually registered in Florida. I just as an agent don't, because I don't do a lot of business there, and I just happen to have one client who's vacationing down in Miami, or I just have one client who just moved to Tampa, whatever just happened, moved to Orlando, the client loves Disney, they just can't get away, they want to move into Disneyland, all good. So I'm going to tell the Florida State Securities Administrator, or at least be ready to tell them, choice B, C, and D. Florida is not going to require that I pay a fee based on how much business I do in Florida under choice A. All right, good. Let's move on. Question number 3. You've already done it, so let's jump right in. All persons required to be registered under the Uniform Securities Act must submit an appropriate registration application along with a consent to service of process and a registration fee. Agents register on forms U4, which require all of the following information except. Which one did you pick? What does the form U4 not require? And many of you just filled out form U4s. I know that, because you had to fill out that form U4 to open that window to take this kind of test. So the vast majority of you have just done this. What did you not have to give the administrator? If you're not sure, if you weren't sure, you might want to think about what's the purpose? What are the administrators going to evaluate an individual's application to conduct securities business in their state? They may want to do a background check on you and know where you lived. They may want to know where you worked. They certainly are going to want to know if there's any criminal history, convictions, or things that happened in that regard. What are they not going to pass judgment on? Your educational history. They're not going to say, hey, did you go to college? Did you get a graduate degree? Did you graduate high school? What's the educational component to register as an agent in a state? It's to pass an exam. And so if you've done that, you've demonstrated the minimum knowledge that they say that you need. Now, your clients might want to know your educational history. Your clients might want to know how you've been trained, but the regulators aren't going to pass judgment on how much education is required outside of passing these exams to become an agent under the Uniform Securities Act. Now, if you want to go a little deeper, you want to get a little extra juice out of this question, residential history, how many years? How many years? Anybody remember? 5 years residential history. How much? How about employment history? This one's nasty. Any of you have trouble with this on your own U4? You were like, oh, that hurts. I got to go way back. 10 years, count them, 10 fingers. And how many are they going to verify? The last 3. The last 3, they're going to go back and contact those employers, make sure everything's good to go. And criminal history, any convictions, any criminal history, they're going to want disclosed on that form U4. I just wanted to note, this question lines up, I think, initially a little more challenging than it actually is, right? What's not required on the Form U4? That's the question here. But if you read that language, which is similar to what you can expect on the actual exam, all persons required to be registered under the Uniform Security Act must submit an appropriate, it's a lot of dense and big words. They throw consent to service of process in there. They throw the registration fee in there. And so my point here is don't get intimidated just because you see a big question. Don't begin to get that anxiety level up and move into the fight or flight mode where you're going to have less ability to remember, to recall those things that are so important for you. So you just want to stay calm. You want to stay collected. Great tool for that, the B in vibes. You just say, oh, I see consent to service process. I see Uniform Securities Act. I see registration. Yeah. Calm. And now you can attack that question carefully and with focus. And that's what we want to do again and again and again. Let's jump on to the next question. Question number 4 asks us, under the Uniform Securities Act, why are broker-dealer firms required to purchase a fidelity bond? What reason? Now, before you even answer this, I know a lot of you already answered it, but if you haven't, I'm going to give you a little opportunity. What is a fidelity bond and what's the answer you're looking for? When you run into these kind of questions, sometimes that prospective, that foreshadow, hey, what am I looking for, helps navigate through some series 63, 65, 66 tougher answer choices where they're going to throw up some distractions. They're going to throw in some unfamiliar words. They're going to throw in some legalese or jargon. So when I see a fidelity bond, I'm thinking about fidelity. I'm thinking about honor. I'm thinking about trustworthiness. Those are the things that come to my mind when I think fidelity bond. And I know bond here, when it's associated with fidelity and broker-dealers, they're not talking about a security instrument. They're not talking about coupons. They're not talking about, money, borrowing money. They're talking about an insurance policy. So when I see that term fidelity bond, I'm thinking it's a policy that will cover a lack of fidelity, a lack of honesty, a lack of trustworthiness. So that's what I'm looking for. All right, A, to protect clients about brokerage house failure. Is that what the fidelity bond does against failure? That's a thing, but is that this thing? No, probably not. Brokerage house failure, what's coming to your mind right now? Anybody getting SIPC? SIPC coming to your mind? If so, nice work. How about B, to ensure compliance with federal tax regulations? Is that what we're talking about? Is this a tax thing? It's not really a tax thing, is it? How about C, to safeguard against employee dishonesty or fraudulent activity? Okay, now we're talking. Because when I saw fidelity, I brought to the surface honesty and trustworthiness. And then in choice C, I see dishonesty and fraud. And I'm thinking, that's a pretty good looking choice right there. I'm not going to pick it. I'm going to do my full analysis. And D's offering to cover losses due to fluctuations in the market. I don't think we ever get that kind of protection. I don't think we ever kind of cover those losses through some kind of instrument, right? We have to bear the risk that we are willing to take. And so for those reasons, what's the best answer here? It's going to be C. It's going to be C. All right, nice job. Nice job. Let's push on and take a look at question number 5. Question number 5 asks us, which of the following statements regarding agents of broker-dealers under the Uniform Securities Act is most accurate? You get a question like this, you can't project. I don't know what accurate statement they're going to have for me. But what I do know is there's going to be 3 statements that have a little bit of truth, but something wrong about them. Something that's not accurate, something that's inaccurate. And I want to make sure that if I'm juicing this question, I know what I don't like about each of the choices. So let's take a look at these. Now, I'm going to start with the one that is correct. The right answer here is C, that agents with discretionary authority may be subject to surety bonding requirements. Surety bond, very similar to a fidelity bond. Different states call this product, this trustworthiness product, different things. So you want to get comfortable with the different kinds of language that we use. So why is that most accurate? That agents with discretionary authority may be subject to surety bonding? Well, we can begin to think about what's a surety bond for? Fidelity. honesty, not doing something wrong by your clients. And if you do, that those clients are going to have the ability to have some degree of recourse, that those clients are going to be able to make a claim against the surety bond, just like we saw in the last question, make a claim against the fidelity bond if there was embezzlement or fraud or dishonesty. And so why is it that we are thinking agents with discretion may have to have this additional layer of protection? Because if those agents have discretion, what can they do? They are authorized to place trades on my behalf without even talking to me. And so for that reason, is there a greater or lower risk of fraud, abuse, theft, misappropriation, all the kind of things that agents do when they're doing bad things? There's a much greater risk. And so the state securities administrator might say, listen, if your agents are going to have that kind of authority, that sort of discretion over client accounts, we're going to impose a little bit of a stricter standard on them. And we're going to put in place something that's going to allow clients or potential victims to get some recourse. And the other thing that this does, the surety bond, is if you want to go buy one of those, what do you think that insurance company, that binding company, is going to tell you as a broker-dealer and tell you as an agent? They're going to tell you the premium that you have to pay. You have to pay for that surety bond. And so if your firm has all kinds of safeguards, double checks, training, continuing education, all the kind of things that are going to lower the risk, what's going to happen to the premium? They're going to lower the premium. Just like you think about your homeowner's insurance. Your homeowner's insurance, they're going to say, hey, do you have a fire alarm? Do you have a sprinkler system? Do you have new construction that's a little bit safer and less likely to burn? You have all those things? Okay, it's going to be a lower premium because the risk is going down. You're like, hey, no, I don't do any of those things. We just live in a matchbox. They're going to say, okay, for you to get fire insurance is going to be super expensive. So a broker-dealer, to keep the price of the surety bonds down, is going to put in place policies and procedures that are going to ensure greater safety, try and reduce that risk. And so that's one of the paths that the administrators use to help create safer broker-dealers, help mitigate the risk of abuse with respect to discretion. Now let's unpack A, B, and D. Why are they not as accurate as C? Choice A. Agents are exempt from any financial bonding or net capital requirements. Now we know that's not true because we saw in C, which we just said was accurate, that they may be subject to bonding requirements. But if you were kind of on the fence, what's the word in A that gives you pause, that you would be like, oh, I'm not sure I want to pick it? Exempt from any. Exempt from any. That means there's no way the administrator could put any kind of financial, any kind of bonding, or any kind of net capital requirement on an agent. Now, that could be the case, but if there was one circumstance where that's not, and there is one circumstance when they have discretion, then A is blown up because it's absolute, exempt from any. So you always want to be careful when you see those kind of words. Any, all, none, never. Those are key words to look for that help you tip the scales on the choice you want to pick. B, surety bonding is mandatory for all agents regardless of their authority. Could be the rule. Could be the rule. Broker-dealers have to have fidelity bonds. That's the rule. But again, what am I pausing? What am I pumping the brakes on? Mandatory for all agents. That means if there's any kind of agent, if there's any kind that doesn't need a surety bond, then B is not accurate. And so we just want to be careful with these kind of words. And D, financial requirements for agents are determined on a case-by-case basis. Could be, right? But do we like that as a regulatory matter? Just as like a policy, do we like this idea that we're just going to make decisions individually? Some people get high bonds, some people get low bonds. As a general rule, we try and avoid that in the regulatory stance because we want things to be fair and equitable. And so we're going to try and lay out general standards that get applied. And so for that reason, D is not quite that accurate. And so we see in most states, choices like C is the actual rule. And if a state turns it on, discretion requires a surety bond. In most cases, the state turns it on for everybody. Anybody with discretion needs a surety bond. Or the state may not turn it on and it's like no agents need bonding. But that's more accurate C than A. All right, very good. Very good. Let's press on. Question 6 asks us about broker-dealer QRS is only registered in the state of Utah. Which of the following trades would be lawful for this firm? What do you think about this? Now, some of you may be thinking, oh, Dave, I don't know. Broker-dealer, it's only registered in the state of Utah. Fine, got it. Can they have a sale of a limited partnership, buy a NASDAQ traded preferred stock, sale of an exchange traded fund, sale of an NYSE stock? And some of you may be right here being like, I didn't really even know where to go on this question. They kind of all look fine. Like, why would or wouldn't they be able to do it? And when you get into that circumstance, and it can happen on these state law exams, especially when they move into some of the more nuanced areas of the law, where they're moving deeper into the exceptions and the exclusions and the commentary or the model policies, you're kind of getting down into the weeds of it all. What are some test-taking strategies I might deploy against a question like this? Well, I might say, all right, right off the bat, are there any things that I think are feeling pretty similar here? And I see buying something on NASDAQ, buying something on NYSE, B and D. Now, NASDAQ, I get it. It's a purchase as opposed to a sale. Do we think that's the differential? Like buying versus selling? That's not usually how the law is talked about, right? Solicitation, engaging in a transaction, an offer for purchase, an offer for sale, they're really treated very similarly. And then I might say, is there a big difference between preferred stock and common stock that I would want to think about? And not really. And so I might come to the conclusion that B and D feel pretty similar. Even though it's purchase and sale, it's a transaction on one of the listed exchanges, NASDAQ versus NYSE. And because of that similarity, I might say, I don't think either of them could be right. Like if I picked one, how would I differentiate the other? And then I might also say to myself, well, what about C, an exchange traded fund? What are the exchanges that these ETFs trade on? Well, they are listed on NASDAQ or they're listed on NYSE by and large. And so maybe C is just the same. I also might say to myself, the difference between C and D feels super narrow. Both are sales. Both are traded on exchanges. An ETF versus common stock, very similar kind of instruments. And now I'm kind of thinking, well, what might be different about a limited partnership? Well, limited partnerships, that's not going to be on an exchange. Maybe that's like a local type of security or transaction that's going down. And so I'm kind of coming to, I'm going to go with A here. Now, I don't know how you got to your answer choice, but that's the kind of analysis I wanted to do this question because I wanted to show you the kind of analysis that you can deploy even if you don't know the underlying law here. The underlying law here is that a broker-dealer can be registered in a state only. Most broker-dealers are registered both at the state level and at the federal level with the SEC, and they would be able to trade on anything they want, including anything on our national exchanges. But here we see that broker-dealer QRS is only registered in the state of Utah, indicating that it's not federally registered. And that, again, it's a little unusual, but we want to be aware of it because this exam pushes us into sometimes a little bit of the unusual parts of the law. And so if you're only registered in the state of Utah, you're not authorized to engage in transactions on the national exchanges, the federal covered exchanges. But what could you engage in transactions in? Securities in Utah, including limited partnership transactions that happen in Utah. All right, so I know that's a little tough. I know that may have been frustrating, but I don't want you to give it up. Let's say you were only able to say B and C are too similar, and you didn't make that leap to how C also was really similar. Or maybe you were like, you know what, Dave, there's a difference in my mind between purchases and sales, but C and D are really similar. And for that reason, I'm going to eliminate both C and D. Well, now you've taken this question from a 1 in 4 guess. Hey, I have no idea about this. That work you did trying to see, are there similar answer choices? Where are they a little bit different? Allowed you to narrow this down to a 1 in 2. So you just doubled the likelihood that your guess, if you were just randomly guessing, is correct. You do that over a couple of questions, 3, 4 questions. If that happens that often, right, you're going to get more points because you will get some guesses right. And we want to make those guesses as informed and as educated and as stacked in your favor as we can. If you were able to only eliminate one choice, say, you know what, state of Utah doesn't do NASDAQ, right? That's not true, but if you were like B is out, maybe you made it a 1 in 3. We want to always be thinking about how can I increase my odds. All right, we got a couple more questions coming your way. Let's take a look at question 7. You've paused this video, you've already answered it, you've thought about this. And you've thought about the broker-dealer that hires an individual to cold call prospective customers and qualify them based on potential firm customers. These calls frequently develop into educational discussions regarding investments. Which of the following statements is true regarding this activity? All right, what do we think? You're hired up, you're doing cold calls. They give you the list, you're just dialing. You're just dialing. And you're going to qualify them, but you're going to also do educational work. You might explain the characteristics of the investments. You might explain who the broker-dealer is. You could do that type of qualification. What do we think here? What do we think? Register or not register? If register, where? Well, when you see cold calling, I want your first instinct to be, you don't have to register. When you see that term cold call to qualify, cold call prospects to qualify, I don't want you thinking registration because that's not rising to the level of engaging in the business of securities. You're not becoming an agent just by virtue of that. Now, some of you are saying, that's fine, Dave, I get the qualification, but what about that educational piece? What about that? And in fact, the law is pretty clear that education, you're not making any suggestions, you're not giving any advice, you're not making any recommendations, you're simply educating. You are providing information. You're not asking them to make any decisions. You're not asking them to make any investments. You're not even aligning what you're talking about to their circumstances. You're not talking about how this may or may not be suitable for them or how this may or may not fit into their portfolio, their investment goals, their time horizon, their tax burden, their risk factors. No, you're just saying, here's the deal with this investment. I'm not going to tell you how you should think about it. I'm just giving you facts about this investment. So qualification and education does not trigger registration. And so for that reason, A is wrong because you don't have to register as an agent in every state where you cold call. C is wrong because we are regularly conducting education. So we're showing education doesn't rise to that level. And D is wrong because you don't have to register as an investment advisor representative to do educational discussions. You don't have to register as an IAR or as an agent. When does it cross the line? When you start taking orders, when you start making suggestions or solicitations, when you start doing suitability analysis, any of those things where you're sort of interacting with the client's portfolio, now we're talking, you're getting a little closer. So look for qualification of leads. That's straight cold call, no registration. Look for education. That's fine too. Anything more than that, now you're crossing that line and you're probably going to have to register as an agent. Question 8. Love this question right here. You do this question yet? If you didn't do this question, you should pause right now and do this question, and then we'll come back. All right, let's get after it. So question 8 tells us about the chief financial officer of a manufacturing firm routinely engages in trades with the underwriter who underwrites each of the firm's recurring debt offerings. This CFO also receives and processes unsolicited requests to trade the firm's common stock. Which of the following statements regarding the CFO's activities is true? What the heck is this? What kind of CFO is this? And why is the CFO doing these things? Great questions, but not the question at hand. And this is the kind of thing in the series 63, 65, 66, the state laws, you're just going to be like, that's weird, but I'm not going to fight it. I'm not going to fight it. So the CFO is trading with their underwriter, the manufacturing company's underwriters of their recurring debt offerings. This is the kind of stuff you're saying, recurring debt offerings. Like, what does that even mean? It's like, well, this manufacturing company regularly, on a recurring basis, consistently goes and borrows money from the capital markets, probably by selling bonds. And when they do that, they hire an underwriter, an investment bank, to help find the buyers for those bonds, to help price that debt, figure out what's the interest rate I have to pay right now, what kind of features do I want to have on them, what's going on in my larger capital structure, all those kind of things. And the fact that the CFO is trading with the underwriter, okay, that's what they say they're doing. The CFO also, this one's even weirder, receives and processes unsolicited requests to trade the firm's common stock. So can you imagine, you got this manufacturing company called ABC. You got ABC Manufacturing Company. You're like, I would love to buy some of that common stock right there. And so you don't go to your broker dealer, you don't call up your agent, you don't go to an online trading platform. No. You just look up ABC Manufacturing Company, you find who's the CEO, and you call the person. And you're just like, hey, you don't know me, but I want to trade. I want to place a trade to buy some of your common stock. Or I've already bought common stock of yours and I want to sell it back to you. And the CFO does it, processes the trade. That's super weird. That is super weird. But which one of these statements is true? And you might be feeling like this is bananas, Dave, but it helps us illustrate the points. It helps us pin down what are the rules and the regs that you have to be that you're responsible for knowing. So which one did you think is true? How many of you got to choice C? That in fact, the CFO need not register as an agent of the firm because she only engages in exempt transactions on behalf of her employer, the issuer. So in this case, the CFO is an agent of the issuer. And as an agent of the issuer, because the CFO works for the company, not for a broker-dealer, because the CFO works for the issuer of the securities, not the investment bank who sells them, that CFO can engage in transactions with underwriters, that's an exempt transaction, and can actually execute unsolicited transactions without registering as an agent. Now, for those of you who are saying, Dave, I don't even understand how this would happen. Agreed. That's not what this question is testing you on, though. By the time you get into those answer choices, I hope what had come to top of mind was, okay, we're talking about the CFO of a manufacturing company, agent of issuer exemption. And then you have a list of, here's some securities that agents of issuers can be exempt, and they engage in those kind of transactions. Here's the kind of transactions that the agents of issuers get to rely upon. Here's that third bucket where agents of issuers, if they're engaging in transactions with employees of the issuer for non-compensation, basically employee stock benefit plans, they don't have to register. And hopefully those things came to light, and then you pin down, oh, underwriter transaction, exempt. Oh, unsolicited transaction, exempt. And then you got to the fact that the CFO does not have to register because of that exemption. Agent, I just get choked up. I just love this exemption. Agent of issuer exemption. All right, good. We got two more questions coming your way. Question number 9. Let's take a look. We got an established broker-dealer. It's introducing a new service to its clients. How wonderful is this? The broker-dealer is excited. And what they are offering is that any client can authorize routine recurring payments from their account at the firm if they execute a written power of attorney. So I can pay my landscapers, I can pay my cable bill, I can pay my health insurance or my disability insurance or any other bills that I have on a regular basis, my mortgage, and draw it automatically out of my brokerage account. That's what they're offering. Which of the following statements about the new service are true? All right, 3 false statements, 1 true statement. If you want to authorize routine recurring payments from a brokerage account, what do you need to do? The administrator may require the broker-dealer carry a reserve balance of assets. They're going to say you're going to have a little bit more backstop for those accounts because you're allowing this automatic drafting out. You're going to have greater reserves. Think cash reserves. Think cash in the vault. You don't typically see it anymore, cash in the vault. But that's the reserves that we want to see because you're allowing for these auto transactions. Let's do a little bit of a tour through some of these other items that are not true. Starting with A, is it the case that the broker-dealer has to maintain director and officer insurance in an amount mandated by the administrator based on the firm's net capital? Is that going to be the case? Not in this circumstance. Director and officer insurance provides coverage in the case shareholders of the broker-dealer sue the directors, think board of directors, or sue the company's officers, think CEO, CFO, COO, in connection with their roles in the business. The fact that you're authorizing routine recurring payments, drafting right from your brokerage account, doesn't align with needing D&O insurance. B, the Uniform Securities Act forbids broker-dealers and their investment advisors from offering auto draft arrangements to their customers. Is this just something that you're not allowed to do? No, that's not correct. You can do that, but what do you need? They're going to say, hey, you gotta dial up the balance. You got to dial up your reserves a little bit to ensure that when customers are relying on that, you have the cash liquid ready to make those payments. The regulators were like, we don't want people thinking that their brokerage account is going to be able to make these payments, and then the broker-dealer is going to have to sell securities or wait for settlement, and if there's a fail, they say, you know what, before you offer that, you're going to have to dial up your reserves. And C, why is that not true? Accounts with recurring payment services must be covered by FDIC insurance in addition to SIPC. Now, what's FDIC? Federal Deposit Insurance Corporation, providing protection for what kind of accounts? Bank accounts backstopped by the federal government. What's SIPC? Securities Investor Protection Corporation, providing protection for brokerage accounts in the event of a broker-dealer failure. There's not an overlap in the account that is handled by FDIC, bank accounts, and SIPC, SIPC, brokerage accounts. Sometimes people get jammed up because there are institutions in our marketplace, some of those largest broker-dealers. I'm sure you're familiar with them. Maybe you use them, where you can have both banking accounts and brokerage accounts all under one brand name. You can log in and see all of your accounts, banking and brokerage and credit and mortgage and auto loan and student loan. You see it all, right? They offer all these services. But in fact, they're being offered by different legal entities, and each of those accounts is independent. If you actually look at your account statement, and again, they consolidate it for you, but if you look at that account statement, you see, different account numbers. Often they're not even structured the same way because my bank account comes out of the bank subsidiary of the bank holding company. My brokerage account comes out of the broker-dealer subsidiary of the bank holding company. And so we see those different kinds of protections. So C, for those reasons, is not going to be accurate. The broker-dealer offering drafting from the brokerage account has to have extra reserve balance of assets. Last question here, question 10. An individual terminated employment with his broker-dealer to pursue a graduate degree in finance. After the one-year program, the individual taught finance courses at that university for 18 months before reassociating with his former broker-dealer. Which of the following statements regarding this individual is most accurate? What do we think here? What'd you get? Of the four choices, which is the most accurate for this individual? That this individual may be required to retake the Series 63 or 65 or 66 or whatever exam we're talking about to satisfy state requirements. And that's because the individual had been out of the industry, unassociated with a broker-dealer, for what period of time for our state securities law exam, 63, 65, 66? It had been more than 2 years, more than 2 years. Now, many of you will have also taken another regulatory exam or multiple ones. Which one of those exams would last 4 years? Which one would last 4 years? That's right, the Securities Industry Essentials exam. That remains valid for 4 years after termination of an association. And so let's take a look at these other answer choices. And I have one more bonus question for you that I'm going to slip into this. B, because he was outside the industry fewer than 5 years, the individual would not be required to retake the Series 63. That's not the case, the 5-year window. There is something about 5 years with maintaining qualification programs. You may have learned about that in some of your other exams. If you did SIE, if you do Series 7, you may have heard about the maintaining qualification program for FINRA, which is a 5-year window, but that's not going to be the case here because one, they didn't talk about that this individual opted into it, and two, when we're talking about the state law exams, where that's really a FINRA program. C, teaching finance qualifies as an industry-related activity. So the individual is outside the securities industry for only 1 year and need not retest. So there's something kind of interesting about this, which is if you were only out for 1 year, then you could just reassociate. So the question is, does teaching finance qualify? And the answer there is no. What do you need to do to be in the industry? Well, you need to be registered and associated with a broker-dealer or an investment advisor rep or an investment advisory firm. And what about D? Both studying and teaching finance qualify as industry related, so you've been continuously in the industry and need not retest for the same reasons as in C. That is not true. When the individual, here's my bonus questions for you, when that individual terminated employment, what was the form that the individual in the firm had to submit? It is the form U5. U5. And when the individual wants to come back into the industry after retaking the Series 63, 65, 66, or whatever exam the individual needs to retake, what form will they use to reassociate? The form U4. All right, gang, I hope you got a lot of value out of this review session, digging into the registration requirements of broker-dealers and agents. For those of you taking the Series 63, that is a very heavily tested topic. For those of you on 65, 66, it is still tested, but the emphasis is more on investment advisors and investment advisor representatives, and holistically, those exams cover more ground. So, in any event, whatever exam you're doing, I'm sure you got some value bombs. I'm sure you learned a little bit here. And even if you didn't, but you did, we also did a little work on how to unpack these kind of questions, those state law questions that are long, that are wordy, that have some unfamiliar terms, jargon, legalese. So let me say thank you for joining me in this, and I can't wait to see how you do on your real exam.